Hello Year 11s and welcome to this series of 4 videos on criminal sanctions. In this video we look at the purposes of criminal sanctions. In the second video we look at imprisonment and the extent to which imprisonment achieves the purposes of criminal sanctions. In the third video, we look at community correction orders and the extent to which community correction orders achieve the purposes of criminal sanctions. And finally, in the fourth video, we look at fines and the extent to which fines achieve the purposes of criminal sanctions. There are 3 things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video so that you can take notes. Use the rewind function if you feel that you've missed out on any information and you want to go back over that information. And the third thing that you need to do is to have your vocabulary sheet open in front of you so that you can include in it definitions of important terms or of any other words that you're unfamiliar with. Once you've finished watching and taking notes on this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information in that reading that you think is useful, then please supplement your Cornell notes with that additional information. Well, let's get started then. On this slide, I've set out the learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. This learning intention is that you should be able to describe the purposes of criminal sanctions. A sanction is a punishment that a court imposes on an accused for committing a criminal offence. That is, when we're talking about sanctions, we are talking about criminal, not civil, law. Look down the left-hand side of your vocabulary sheets, find the term sanction, and write this definition in there. If an accused is charged with a criminal offence that is an indictable offence and the accused pleads not guilty, then the accused will have a trial in either the county court or the trial division of the Supreme Court. It is the role of the jury to decide whether the accused is guilty or not guilty. That is, it is the role of the jury to decide the verdict. If the jury decides that the accused is guilty, then it is the role of the judge, not of the jury, to decide the sanction that will be imposed on the accused. On the other hand, if the accused has been charged with a criminal offence that is a summary offence and the accused pleads not guilty, then the accused will have a hearing in the magistrate's court. There is no jury in the magistrate's court, and so it is the role of the magistrate to both decide whether the accused is guilty or not guilty, and, if the accused is guilty, to decide on the sanction that will be imposed on the accused. In many cases, the accused will plead guilty to the criminal offence with which they have been charged. If the accused has been charged with an indictable offence, then there is no need for a jury to determine whether the accused is guilty or not, because the accused has pleaded guilty. In that case, the accused will proceed straight to a sentencing hearing, and the judge will decide on the sanction that is to be imposed on the accused. If the accused has been charged with a summary offence, then there is no need for the magistrate to determine whether the accused is guilty or not, because the accused has pleaded guilty. In that case, the accused will proceed straight to a sentencing hearing, and the magistrate will decide on the sanction that is to be imposed on the accused. Legislation, that is, acts or statutes passed by Parliament, sets out the types of sanctions that a judge or magistrate may impose on an accused for the different types of criminal offences. In the next 3 videos in this series, we will be looking at 3 types of criminal sanctions, being imprisonment, community correction orders, and fines. Now, it is very important not to confuse the types of criminal sanctions, that is, imprisonment, community correction orders, and fines, with the purposes of criminal sanctions. When a judge or magistrate is deciding the type of sanction to impose on an accused, that is, whether to sentence the accused to imprisonment, a community correction order, or a fine, the guiding principle is that the sanction must be appropriate to the crime. In deciding what sanction is appropriate, the judge or magistrate must decide what purpose or purposes they are trying to achieve. For example, if a judge thinks that the most important purpose in sentencing the accused is to punish the accused, perhaps because the offence is a very serious one, such as violent assault, then the judge might decide that imprisonment is the most appropriate sanction for the accused. This is because imprisonment is very effective at achieving the purpose of punishment. In such a case, the sanction is imprisonment and the purpose of the sanction is punishment. On the other hand, if a judge thinks that the most important purpose in sentencing the accused is to rehabilitate the accused, perhaps because the accused has committed the offence under the influence of a drug addiction, then the judge might decide that a community correction order is the most appropriate sanction for the accused. This is because a community correction order can include a condition that requires the accused to undergo treatment, such as treatment for drug addiction, and so is very effective at achieving the purpose of rehabilitation. In such a case, the sanction is a community correction order and the purpose of the sanction is rehabilitation. The Sentencing Act 1991 of Victoria sets out the 5 purposes for which a court can impose a criminal sanction, and our learning intention requires you to be able to describe each of these purposes. These 5 purposes are punishment, deterrence, rehabilitation, denunciation, and community protection. Importantly, and as you'll see from the next 3 videos, the sanctions of imprisonment, community correction orders, and fines achieve these purposes of criminal sanctions to different extents. Now, you need to be very careful in the language that you use when you are describing or applying these purposes. If a SAC or exam question requires you to describe or apply a particular purpose, such as specific deterrence, then you must be careful not to slide into a different purpose by using language that relates to that different purpose. For example, specific deterrence is about discouraging the offender from committing future offences. So you could say that imprisonment achieves specific deterrence because it deprives the offender of their freedom, which will discourage the offender from committing further offences because they will not want to risk being deprived of their freedom again. However, if you said that imprisonment achieves specific deterrence because it punishes the offender by depriving the offender of their freedom, then you have moved from specific deterrence to punishment, which means that you will not have answered the question. Likewise, if a SAC or exam question requires you to describe or apply 2 purposes of a criminal sanction, you need to be careful that you use language that relates to those 2 purposes and that you do not slip into language that relates to a 3rd purpose. If you slip into language that relates to a 3rd purpose, then the examiner will not read anything that you write in relation to that 3rd purpose. For example, if you choose as your 2 purposes deterrence and community protection, then you must be careful not to refer to punishment, such as by saying that imprisonment protects the community because it punishes an offender by depriving them of their freedom. However, if you are careful to tie back your answer to the purpose that you're talking about, then you can still incorporate other purposes. For example, if you're answering a SAC or exam question that requires you to describe one purpose of community correction orders, then you could choose as your purpose community protection. In that context, you could say that community correction orders achieve community protection by rehabilitating an offender because if the offender is rehabilitated, then they are no longer a threat to society, as a rehabilitated offender will not commit further offences against society. Let's now look in turn at each of the 5 different purposes of criminal sanctions. The first purpose for imposing a sanction on an offender is punishment. This is an important purpose because punishing the offender for the crime that they have committed satisfies society's need for revenge against the offender. You can imagine that if offenders were not appropriately punished, then the victims, or perhaps their family or friends, would take the law into their own hands and impose their own punishment on the offender. This would represent a serious breakdown in the rule of law and social cohesion. In Australia, the most serious punishment that can be imposed on an offender is imprisonment, that is, being sent to jail. We no longer have capital or corporal punishment. Capital punishment means the death sentence. We used to execute offenders in Victoria by hanging them. The last person to be hung in Victoria, and indeed in Australia, was Ronald Ryan, who was executed in 1967. Victoria subsequently abolished the death penalty in 1975. Corporal punishment is the infliction of physical harm on an offender, for example, whipping them. Again, in Australia, we no longer have corporal punishment. The second purpose for imposing a sanction on an offender is deterrence. Deter means to discourage, and there are 2 types of deterrence that you need to be aware of. The first type of deterrence is specific deterrence. Specific deterrence means discouraging the offender from committing further offences, that is, discouraging the offender from becoming a reoffender, otherwise known as a recidivist. The second type of deterrence is general deterrence. General deterrence means discouraging other members of the community from committing similar offences to the offence committed by the offender. So, specific deterrence is focused on the actual offender, whereas general deterrence is focused on the community at large. Look down the left-hand side of your vocabulary sheets, find the terms specific deterrence and general deterrence, and write these definitions in there. Now, deterrence is an excellent purpose to use when you are answering a question that requires you to describe or apply a purpose of criminal sanctions. This is because deterrence is one purpose of a criminal sanction, but within that purpose you can refer to both specific deterrence and general deterrence. This is a great way of adding detail to your answer. However, if you want to do this, you must first refer to the purpose as being deterrence, and only then get stuck into both specific deterrence and general deterrence. The third purpose for imposing a sanction on an offender is rehabilitation, that is, to rehabilitate the offender. Rehabilitation means assisting an offender to change their attitude or behaviour so that they do not reoffend. Look down the left-hand side of your vocabulary sheets, find the term rehabilitation and write this definition in there. So, for example, if you are given a community correction order, then one of the conditions of that order can be that you undertake some kind of training or further education program. Even in jail, there are programs under which prisoners are able to undertake training or further education so as to obtain a qualification. The purpose of these programs is to enable the offender to obtain employment, and by obtaining employment, it is hoped to rehabilitate the offender so that they can fit back into society rather than continue to follow a life of crime. Similarly, it may be that an offender commits an offence because they're addicted to alcohol or drugs, or because they have difficulty controlling their temper. As part of a community correction order, the offender can be ordered to undertake treatment for their alcohol or drug addiction, or to obtain counselling for anger management. The purpose of imposing these kinds of conditions is to rehabilitate the offender by treating the cause of the offender's offending. If an offender commits an offence because they're addicted to drugs, for example, they might rob a bank so that they can obtain money to buy drugs, and if you are able to treat their drug addiction, then that is a good way of ensuring that the offender will not reoffend. You have then removed the cause of their offending, which is the drug addiction. The fourth purpose for imposing a sanction on an offender is denunciation. Denunciation means showing the court's disapproval of the offender's behaviour. Look down the left-hand side of your vocabulary sheets, find the term denunciation and write this definition in there. The way that a court denunciates an offender's behaviour is by imposing on the offender a sentence that is at or close to the maximum sentence that can be imposed on the offender for the offence that the offender has committed. The court might want to achieve the purpose of denunciation where, for example, the offender is guilty of committing a drunken violent assault. In that case, the court may wish to show its disapproval of people who cause serious injury to others while they're under the influence of alcohol by imposing a very severe sentence on the offender. Another situation where a court may want to achieve the purpose of denunciation is where the offender has abused a position of trust. Perhaps the offender works in a bank where they have access to money and they have embezzled, that is stolen, money from the bank's customers. In that case, the court may wish to show its disapproval of people who abuse their positions of trust by imposing a very severe sentence on the offender. The fifth and final purpose for imposing a criminal sanction on an offender is to protect the community from the offender. The most obvious sanction that protects the community from an offender is imprisonment, because while the offender is in prison, the offender is not in a position to harm society by committing further offences. However, a community correction order can also protect the community from an offender. Unlike imprisonment, a community correction order does not involve the offender being sent to jail. However, a community correction order can include a condition that requires the offender to participate in a rehabilitation program such as drug or alcohol addiction treatment or anger management counselling, where the offender's addiction or anger issues are the cause of the offender's offending. If the offender is successfully rehabilitated, then the community is protected from the offender because a rehabilitated offender will no longer commit offences as the cause of the offender's offending has been removed. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you should now be able to describe the purposes of criminal sanctions. You now need to read the pages from the textbook that are referred to on the first slide. And if you find any additional information from that reading that you think is useful, please supplement your Cornell notes with that additional information. The next video that you need to watch and take notes on is the video on imprisonment and the extent to which imprisonment achieves the 5 purposes of criminal sanctions. Thank you very much for your attention.